Friends, today we'll be starting with a new module, and the module is on exempted information. And as we are all aware of the fact that under the Right to Information Act, there are some information that are not available and that cannot be shared. And those are the categories of exempted information that we're speaking about. Now, if we find the genesis of the Right to Information Act in the Constitution of India through Article 19(1)(a), which spoke about the freedom of speech and expression, then we will all appreciate that yes, the Constitution is the basis for all rights and all freedoms to be enjoyed, including the right to information. And hence, the Constitution will be a guiding document and will be the vision document for restricting this right or curbing the exercise of the same if it is necessary for it to be done so. Because we always believe that rights are not absolute, right? There are reasonable restrictions that have to be imposed by the state. And you will notice that no liberty is going to be an absolute liberty. There will be restrictions that are imposed by the statute. There could be restrictions that are imposed by the fundamental law, that is the Constitution of India. Restrictions can be imposed by judiciary through interpretation. And this is, as we say, rights are evolutionary in nature, that we tend to experience newer rights. There could be newer restrictions based on the same. And hence, I think what is important here for us to analyze is that when we consider the freedom of speech and expression, which is a basic freedom, which catalyzes our thinking process, our expression processes. And in a democracy, you will definitely want free speech because that is what makes a democracy far more vibrant. One of the factors that I have always looked at is when we talk about reasonable restrictions, those are restrictions that ought to be reasonable. Right? And if you look at Article 19(2) of the Constitution of India, they do speak about certain of those restrictions that are necessary to curb the necessary misuse or abuse of the freedoms that are guaranteed under the Constitution of India. Now, this is not unique to India. You will notice that reasonable restrictions on freedoms and rights is something that is there as a matter of state and international policies. And even when we look at international declarations, you will definitely find those reasonable restrictions that are laid down from time to time. So when one exercises his freedom of speech under Article 19(a), you will notice that the right to express one's views and opinions at any issue through any medium, be it by word of mouth, writing, printing, pictures, films, etc. It is including the freedom of communication and right to propagate and publish opinions, right? But this right cannot be something that cannot be controlled for its abuse, because when you are writing, when you are publishing, when you are making a film, it could probably infringe others' rights. And hence, if there is no restriction on the rights, it is a tendency of abuse and misuse of the same. And hence, we should not confuse and say that by imposing reasonable restrictions, there is a kind of a control. But I think the control is a necessitated control, and it is a control to make people exercise their freedom far more responsibly and not in an irresponsible manner. Now, one of the basic elements of a healthy democracy is to allow its citizens to participate fully and effectively in the social and political process of this country. Now, when citizens are allowed to do that, I think it's very important that the citizens know where they should exercise this freedom and where they are not supposed to exercise the same. Now, let us look at Article 19(2), which has certain reasonable restrictions in the Constitution of India itself. And those restrictions are very, very critical and important, because as we go forward in looking at the restrictions on the Right to Information Act 2005, the constitutional basis is something that will always be referred to, or will always be a guiding document to interpret what are the restrictions that the Right to Information Act actually gives forward. Now, the reasonable restrictions are based on the security of state. Now, please note under the Right to Information Act as well, security of state is an exempted information. Now, security of state is very vital because I think a government has to protect its citizens from aggression from external neighboring sources. And hence, when it comes to the security of the state, the government must have all and absolute power to impose restrictions that may affect the day-to-day activity and lives of citizens. And hence, a reasonable restriction on the ground of security of state is always justified. However, the term security is a very crucial one, right? In terms of security of state, we only refer to very serious and aggravated form of rebellion or war or external aggression against the state. And you will notice that this should not be something like some kind of a civil unrest within the state. So the security of state has serious connotations, and security of state should not be invoked whenever there is, say, a simple unlawful assembly, a riot, or something like that. So I think the security of the state is something that affects the borders. It's some kind of an external aggression, and that is, I think, a matter of serious concern. And based on security of state as a valid ground, please note there could be reasonable restrictions imposed on your freedom as well as on the right to information. Friendly relationship with foreign states. Kindly note the Constitution also has this as a reasonable restriction under Article 19.2. The same can be found under Section 8.1a of the Right to Information. So, you will definitely find a lot of parallel that can be drawn from the constitutional interpretation of these provisions with what that has been stated in the Right to Information Act. Now, when you talk about friendly relationship with foreign states, you will notice, especially in today's globalized world, a country has to maintain good and friendly relationship with other countries. And sometimes there are a lot of information, or there could be a lot of potential that if citizens in a country are allowed to exercise their freedom unabated, potentially it could have an effect in the relationship that two governments share between themselves. And hence, you will notice that there could be prohibitions on the exercise of certain freedoms and rights, especially when there is some kind of a malicious propaganda against a friendly foreign state. So you would never know when groups and NGOs would probably undertake such malicious propaganda, and usually foreign soil is definitely used so that you can evade prosecution in that country. And hence, I think one of the most important elements is you cannot have malicious propaganda against a foreign state, which is actually something that we think is prohibited. And I think anybody who jeopardizes the good relationship between India and any other foreign state can be imposed with some kind of reasonable restriction. That, I think, is also a very important aspect in trying to understand and deal with the provisions of the Right to Information Act. You will also notice that public order is a very important restriction. Maintenance of public order, you will notice, is one of the most important functions of the state. The state has to maintain tranquility, peace. That is the purpose of the collective spirit of a democratic state. The political society must exercise power, responsibility, and not instigate violence. It is something which is an internal regulation of the government, but nevertheless, I think a state has a basic duty to maintain peace and order. And whenever there is any kind of disturbance in the exercise of peace and order by the state, then definitely reasonable restrictions will be imposed. And you will notice that any kind of communal disturbance, strikes, which are promoted or which are conducted with the sole motto of creating an unrest, even if it is so between workmen or between a particular community against another community. In those cases, I think there could be reasonable restriction that can be imposed on the ground of public order. I think the state has a duty to check violence. The state has a duty to ensure peaceful enjoyment of life and property of the citizens. And please note, the state's primary role is public safety. And when it comes to the issue of public safety, the rights will have to be curtailed, the rights will have to be moderated, and the rights will definitely not be allowed to be abused or misused in those contexts as well. You will also notice that when we talk about public order, the state will have to check internal discord and rebellion if it arises in certain parts and pockets of the country. And this necessarily is not an armed rebellion, but it could be a rebellion against the state. It could be a rebellion against the interest of government, and it could be something that results in unfair, untrue criticism of the government, thereby instigating public disorder. Now, I think all of these are necessary in terms of the kind of restrictions that are to be put in place, and hence you will notice that any kind of freedom of speech, expression, or information, as the case may be, which has a tendency to create public disorder uh, and which would lead to the breach of peace, will not be entertained under the Indian legal system. I think the reasonable restriction under Article 19.2 continues to include decency or morality, as the case may be. Now, I think decency and morality of a society are some kind of principles, standards that govern any kind of legal system. And you will notice that in case anybody breaches decency and morality, it could be a criminal offense, in the sense that the Indian Penal Code also has instances where anybody who actually conducts himself or herself in an indecent or an immoral manner could be punished by the law. However, you will notice that nobody has the right to sell and distribute and exhibit obscene words, obscene material in any public place. Though there is no standard fixed for such kinds of moral or indecent behavior, but I think the standards of morality have been set, and though it varies from time to time and place to place, you will notice that in India, the standards of morality are based on the fact that you cannot probably have obscene material, exhibit them in public place, and you cannot misuse your freedom in those contexts as well. Contempt of court is another important restriction. You will notice that the judiciary plays a very critical role in any democratic institution, and the respect to such institution and order of the institution has to be maintained at all costs. And please note, in India, contempt of court can either be civil contempt or criminal contempt. And you will notice that the only defense in contempt proceeding is truth and nothing else. And hence the judiciary cannot be held on to issues that affect the image, the respect of the institution, in terms of people who think that they don't have to abide by the orders of the court. Because if then people escape by non-abiding the orders of the court, then it will result in a chaotic society and a chaotic situation. So I think contempt of court I think is a very important ground. You do not have a similar provision in the Right to Information Act, but you have certain aspect wherein the privileges that are granted to the court include the privilege to withhold certain information as well. Defamation, obviously, no right can be used to cause disrepute to any person or his stature, and I think this is an important restriction on anybody's freedom. I think man's reputation is very, very critical and important, and no right can be exercised to bring that down. And you will notice any kind of ridicule or comment that is false, that that invokes hate towards that individual, I think will quantum or create the offense of defamation and could be a restricted aspect under the Right to Information Act as well. Incitement of an offense is also very critical. You will notice this is also something that is there under Section 81A of the RTI Act, that any information that may, and this is a issue of the degree of probability based on the content of the information, and if it leads to an incitement of an offense, that could also be the reasonable restriction that can be imposed on the state. Finally, the sovereignty and integrity of India, like we talk about the security of the state, the sovereignty of the country, which is protecting the supreme power in the government, protecting the supreme power of the people, and keeping the interest of the society in general in India, I think are very, very critical and important. And hence, any freedom, any right that affects sovereignty and integrity of the nation will not be entertained, and yes, curtailment of that curtailment of that act is necessitated, and the constitution permits such negotiation as well. So what we conclude by point 1 here, that article 19.2 I think is a very, very important guiding principle for the interpretation of section 8 of the Right to Information Act. I think the constitution from time to time has laid down those kinds of elements which should be the basis for an objective evaluation of any kind of reasonable restriction that may have to be imposed on the right to information law. Interestingly, when we look at the provisions of the Act per se, you will notice that exempted information in India is not only regulated by the Right to Information Act, they could have been regulated by other legislations as well prior to the RTI Act 2005. For example, section 123 of the Indian Evidence Act also had an aspect which stated something like this. It said that no one shall be permitted to give evidence derived from unpublished official records, right? So that's something that is provided under the Indian Evidence Act. So unpublished official records relating to the affairs of the state, right, cannot be used as evidence unless the permission of the officer has been sought. So this was very kind of a restriction, because the government would clearly withdraw records saying that they are yet to be published, and unless they were published and unless the officer of the head of the department had given permission, those government records could not have been produced as evidence in a court of law. So that was kind of a restriction on how information and government recording was actually being done. Similarly, when you look at the Right to Information Act, you will notice that it has a mention of this legislation called the Official Secrets Act. Now, you will notice that the Official Secrets Act is probably the reason why the RTI Act was brought into place. However, the Official Secrets Act also, and please note, this was made by the British government. Then the government was not a democratic government, it was not the government of the people. Nevertheless, they wanted to withhold a lot of information from the Indian citizens, and hence the state was clearly prohibited from sharing information, especially those that are classified and those which the government thought should not be provided for. So you will notice that the Official Secret Act continued to be in force, and it denied a lot of information to the Indian citizens, saying that it was government classified information. And till 2005, I think this law stopped government from sharing that kind of information. However, right now, this provision under the Official Secret Act seems to have been neutralized. Today, the government will only apply the Right to Information Act, which is the reason why we say that the Right to Information Act has overriding powers. So any law that is inconsistent with the Right to Information Act, to the extent of that inconsistency, the Right to Information Act will have an overriding power. And hence, there you will notice that there has been a neutralization of the Official Secrets Act and its functioning. So the government officers will now only be guided by the provisions of the RTI Act and not the Official Secrets Act. Last but not the least, the Central Civil Service Conduct Rules also had restrictions on how government servants, without a specific order from the government, cannot share any information externally. So they were duty bound to protect the information. They were under oath to keep it as state secret, and hence any official document or any part thereof or any information that is relating to any government servant or to the government cannot be disclosed unauthorizedly. So the Central Civil Service Conduct Rules governed the conduct of Central Civil Service officers, and they were duty bound under oath not to disclose or share this information with any other individual or with any other public. So these were probably, the kind of background to the restrictions on Right to Information Act, which I thought was very relevant in terms of laying the foundation to understanding what we would want to call as exempted information. Now, if you go further in trying to understand why restrictions are necessary, I think the Central Information Commission in 2008, in this case called Rakesh Sanghi, versus the International Advanced Center for Powder Metrology and New Materials, Hyderabad, held that citizens' right to seek information is not absolute, but is conditioned by the government's right to invoke exemption whenever or wherever such exemptions are applicable. The Central Information Commission has held no canon of transparency or public interest would justify that research and technological institutions part with the research data or such vital information without expecting to benefit tangibly or intangibly from such exchange or disclosure. So the CAC has acknowledged the fact that there are many information that are exempted and should not be made available, and this is a prerogative of the government, and the government is duty bound to protect the information and not to disclose it under the Right to Information Act. At this point of time, it is very pertinent to mention over here, though this is something that is going to be covered in greater detail and depth in the coming module. But you must also note that when we are talking of exempted information, there are exempted organizations under the purview of the Right to Information Act. And the statute very clearly says that the RTI Act may not be applicable to such organizations. And hence, which are these organizations? The list of organizations that are exempted from the application, rather, I must say the general application of the Right to Information Act, are most of intelligence agencies or security agencies. Now, you would notice that under Section 24 of the Right to Information Act, the government, by a notification, can exempt organizations from the application of the Right to Information Act. And if the government decides to do the same, you will notice that the government has the right in terms of seeking those exemptions even through amendments later on.